The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission or Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchored their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the SAL-Ns prior to his appointment as Chief Justice in 2010 were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the Articles of Impeachment.